Oh, there you go, recording. We are excited to present information for you or to you. Hopefully, you leave this webinar with some valuable information. And yeah, let's just get started. Okay, so this is our webinar. This is Brands and Influencers, Key Legal Considerations and Federal Trade Commission Compliance. It's presented by us, Ameri Law PC. Yeah. Okay, as quick housekeeping, we will have a Q&A at the end of the presentation, so feel free to submit any questions that you have via the Q&A button that should be at the bottom of your screen if you're on desktop. I'm not sure about mobile, but it should also be available to you. After the end of this webinar, everyone should receive a link to the recording along with this PowerPoint presentation, I believe. And we will also be offering an opportunity to dive just a little deeper at the end of the presentation. So please stay tuned. Introductions. So starting with Nina. Nina Ameri is the founder and principal of Ameri Law PC. She is a well-known, highly respected attorney with 20 years, just about 20 years of experience practicing law. Since opening her own law firm back in 2019, she has dedicated her practice to helping creatives like content creators and other business owners negotiate brand deals and sponsorship deals to ensure that they are protected every step of the way. She also has extensive experience in helping these creatives protect their IP and themselves by forming and maintaining business entities, filing trademarks and copyrights, etc. Caitlin Bradshaw is an associate here at Ameri Law PC. Having grown up in a family with a deep passion for music and art, Caitlin developed her own passion in helping creatives and artists retain their rights to their works. It was this experience that led her to law school to become an entertainment attorney. Since starting at Ameri Law as a law clerk in 2022 and then an associate in 2024, Caitlin has been able to gain wide-ranging experience in numerous types of entertainment contracts and intellectual property matters. My name is Kyla Nguyen. I am also an associate here at Ameri Law PC. I've always had a passion for entertainment, born from my love of art, literature, cinema, music. Since I was young, I loved reading fantasy books and watching anime. And although I originally wanted to be like an artist or like a novelist, I eventually discovered my passion for protecting creatives, and I now love to advocate on their behalf. Like Caitlin, I also started as an a law clerk in 2022, and then became an associate in 2024. That's enough about us. I think now we can move on to why you're all here to discuss brands and influencers. And I'll let Nina take it away.
Okay, so why are we here? We at Ameri Law have started working with influencers kind of organically. I started off in traditional film and TV, and then around 2019, 2020, I started working with a lot more creators on social media platforms. This is a very fast-paced and constantly changing world. And that's why we felt it was important to do a presentation on influencer marketing, brand representation. Social media is now the primary way that companies target consumers. And so for those of us that are working in this space, we really need to understand what do influencer agreements entail, what are kind of the major FTC rules that we need to be aware of. We've advised many clients on how to structure these contracts, how to navigate IP rights, how to comply with FTC rules. So again, that's why we're hosting this webinar. We want to equip our clients with the legal knowledge necessary to mitigate risks. Please note that we do represent both influencers and brands. So because of that, we have very unique experience. And I think that through that experience, we've been really able to help both sides maximize opportunities in this dynamic industry. So, this influencer marketing space, like I said, kind of came on my radar 2019, 2020. In 2020, the um, the number for influencer marketing was 9.1 billion. Now in 2025, we are at 32.55 billion. So as you can see, the growth is insane. 84% of brands say they believe influencer marketing to be the most effective. 63% of shoppers say they're more likely to buy a product if it comes from an influencer that they know, like, and trust. So because influencers drive such significant consumer purchasing decisions, it's important to understand the legal issues. And when you do, those are the keys to success. Here is just kind of like a smorgasbord of brands that really have been using influencers. As you can see, big names like Dunkin' Donuts, Calvin Klein. The list is endless. This is just a small little gamut. Okie dokie. So, what are the basics? First off, what actually is an influencer agreement? I feel like a lot of people throw that term around, and I don't necessarily know if they're using it in the right way. But essentially, it's a legally binding contract between a brand and an influencer that outlines what their partnership is going to look like. So, why are these agreements essential for both the brands and the influencers? Let's start with the brand perspective. So, for the brand, it ensures that that influencer is going to align with the brand and the quality of their product. It's going to protect the brand's intellectual property, their reputation, and like any agreement, it's going to set clear expectations and legal protections. And then on the influencer side, you know, you have to remember influencers are artists, they're creative folks. And so we want to guarantee fair payment. We want to make sure that it defines who owns the content, what is the usage that the brand can use, and then also has a provision on how disputes are going to be handled. So again, they protect both brands and influencers. Um, Today, we're going to go over some of the key clauses that ensure compliance, protect IP, and I think I want to, make sure that we get through the most important ones today. We believe those to be confidentiality, indemnification, intellectual property, and morality clauses.
Everyone. Like Kyla said, I'm Caitlin, and I will be talking to you guys about some of these contract clauses. So, first up is confidentiality and non-disclosure. So, everybody kind of understands the general meaning of confidentiality. In a contract, this functions to protect your proprietary brand information and influencer access to that data. So, as you're working with the influencer, obviously, they're going to come into contact with certain information from your company. This could be anything from like the ingredients in a product or how you market it or your client list, things like that. So, confidentiality clauses function to protect all of that information so that the influencer can access that information to properly do their job, but they can't disclose it to anyone. So, it protects all your trade secrets and stuff like that. An example of a confidentiality clause like this would essentially boil down to the influencer would agree not to disclose any of this information. So that would be to any third parties, to any competitors, things like that. There's generally a few kind of exceptions, which is simply for the influencer to disclose for like legal representation or tax purposes or things like that. So generally, these confidentiality clauses do come with a few exceptions, but we try to limit those as much as possible. So we're going to do a little pop quiz. Here's your question. An influencer is asked to sign a contract with a brand to promote a new product, but the influencer doesn't want to be bound by confidentiality regarding their own content and personal details. Would a confidentiality clause be appropriate to include or exclude in the agreement? Okay, so I guess the poll's not working. Sorry about that. Technical difficulties. So I'm just going to answer. In this case, a confidentiality clause would still be appropriate. The confidentiality clause would be limited to only protect the brand's new product and the information about that product, but we would allow, obviously, the influencer to freely discuss their own content and personal details. So it would just be carefully crafted, but it would be included in the agreement so that we can protect the brand's new product. And next up is indemnification. So I'm sure everyone has seen this somewhere in like agreeing to, Apple's terms of service or whatever it might be, whatever website or technology you're using, it almost always will have an indemnification clause. What this means is that this clause basically provides protection for both sides. So um, essentially, the indemnification is it means that one party will agree to take responsibility and cover the cost if the other party gets sued or faces legal action from a third party based on their responsibility. So this is usually broken down into different responsibilities, whether it's for the brand or for the influencer. And if the influencer doesn't, adhere to their obligations or like do the required responsibilities of adding like hashtag ad on a post, usually the influencer will agree to indemnify the company for not meeting those expectations or obligations of the contract. So that means if the brand now gets sued for that action or for that misstep, then the brand will go to the influencer and say, hey, we're invoking that indemnification. You have to come in and defend us. And then the influencer would be responsible for paying the legal fees, damages, etc. And this can go both ways. So if the company, engages in illegal practices, they might be required to um, indemnify the influencer for those illegal practices. So the influencer won't be responsible for that, right? So basically, it helps not only ease financial burden, but it also just helps with like risk shifting, and it helps to cover a party in case one of the other parties doesn't do what they're supposed to do. And exclusivity. So everyone always wants everything to be exclusive, right? Um, an exclusivity clause will essentially restrict an influencer from promoting competing brands or products, usually within a specific defined period of time. The reason that we're saying an exclusivity clause usually restricts the influencer from promoting competing brands is because for obvious reasons, a brand, number one, won't be competing, or I apologize, a brand won't be promoting competing brands or products for obvious reasons. And the brand can't be expected to only work with one influencer during that time. So, most often, these exclusivity clauses are going to restrict the influencer. But that being said, influencers have been able to get certain exclusivity clauses from brands so that the brand doesn't, hire a similar influencer. So, an example would be like if an influencer is a like wrestling fighter and they're contracting with a specific brand, they might ask that brand either not to contract with other athletes or other athletes within like their wrestling fighting industry or something like that. So Most often we see this restricting influencers, but it can also double to restrict a brand as well. So if you are an influencer, I would push for this in your agreement. That being said, in California, non-compete clauses have always been extremely limited and generally unenforceable. So non-competes are basically a separate clause in the contract that would say, I agree not to work with this other company for X amount of time after I'm done being employed here or during the time that I'm employed here. Generally speaking, California doesn't really enforce these types of clauses. So when we draft the exclusivity, it needs to be absolutely narrowly tailored. So only for either a specific time frame or that one specific campaign that they're engaging in. It cannot be indefinite. So a brand cannot prevent an influencer from working with their competition forever, because that's not going to be held up in California. Further, these clauses need to completely, basically only restrict the specific items that they're looking for from that influencer. So they have to clearly define what brands they're not allowed to work with or what products they're not allowed to endorse, and specific to that time frame. Generally, what we see is usually no more than like a 6 month or a 12-month duration. That's usually the longest.
All right, so payment terms. Um, Getting paid is very important. And the question is how to make sure first that you give fair compensation and that you get fair compensation. Um, First, there's a few common payment structures that we typically see in influencer deals. They can be flat fee, which is just a fixed payment per campaign, or like per deliverable of services, which could be anywhere from like 5K to 20K for one TikTok post, one Instagram post, or it could be a longer, like you will deliver 6 posts and this is the sum that you will get. Another structure that we often see is performance-based. You are probably all familiar with these structures. Usually when you see like, oh, I'm an Amazon affiliate. If you click this link, I will get a percentage. But yeah, this is usually measured by tracking systems like influencer specific links or affiliate codes. The third one is just a combination of the two that are above. I think those are starting to come in more often. We haven't seen them too much, but usually we see flat fee or performance based. Common payment timelines is just when are you getting paid? It's either going to be net 30 or net 60. Net 30 is just payment is due 30 days after either content delivery or receipt of a valid invoice from the influencer that's rendering the services. When it comes to the language of the agreement, you want to make sure you understand exactly when you will be receiving payment, whether it's net 30 or net 60 from completion of services, or when it's upon receipt of valid invoice, or even when it's upon execution of the agreement. So you want to make sure. There's also milestone payments too, payments split across deliverables upon receipt of half of the deliverables, one TikTok post, all of the TikTok posts. There are retainer agreements, which are usually applied when there's a long-term collaboration with set monthly payments. And then there's also usage-based fees, which is they are additional payments for extended content use. So the original agreement might contemplate a use for a span of 30 days, but in the event the brand wants to continue using this content, they might offer up an additional fee. And that's usually negotiated and agreed to in the initial agreement. Additional considerations for payment can include late payment penalties, upfront deposits, and a reimbursement term if the business is covering any of the influencer's production cost. All right, IP, or the question of who owns the content. So in case you didn't know, and if you did know, then this is just a refresher. Copyright is usually created as soon as the copyrightable thing has been created. So for example, if an influencer makes a video or like a TikTok post, boom, they own a copyright, or a copyright has been created in that tangible, fixed audio visual content. Now the question is, who actually owns it when you are engaged to render services under like a brand sponsorship or a deal, something like that? And a great way to outline who owns it is by specifying it in the agreement. Typically, the influencer will retain the copyright to the TikTok post or to the Instagram post or to the tweet that they are posting, or X post, I don't really know what's called anymore. And the brand will want to have a license to use that content for their purposes. This could be either just to repost it on their own account, have it live on their feed, or use it as like those paid ads that you see pop up on Instagram. The question is, how long can this content be used by the brand? In what way? And can the brand make alterations should they need to, etc.? These are all things that you want outlined in the agreement, so it's clear that, first of all, the influencer still owns copyright to it. They're not giving up their copyright just because they're entering into a brand deal. But also, how long can the brand even be using this? How long can they boost these posts? Can it live on their account in perpetuity? Can they edit it should they need to? One example IP clause that we usually see and that we usually will add into agreements is that the brand will have a perpetual license to use the content created by the influencer for promotional purposes. This is to make sure that like once the term of the agreement ends, they don't need to then go back and then remove all these posts. I know our poll is not working, but the pop quiz was. So we have an influencer that creates a series of posts promoting a brand's new product. The brand wants to ensure that they have the right to use the content in future marketing campaigns. Which clause should the brand include in the agreement? I'm going to pretend everyone knows this answer and is saying, yes, they need a perpetual license to use the content created by the influencer. Yay, we did it. But yeah, use is very important when it comes to the content that the influencer is making for the brand.
Oh boy, our funnest topic of the day. Lucky me, I get to present. All right, morality clauses. So this clause emerged, I think, really from what was in traditional talent deals from film and TV. We know that there's some bad boys and bad girls out there that when they're offset or out off camera, might engage in activities that are distasteful to the brand. Obviously, as a brand, you don't want that influencer's behavior to now be associated with your product. We've seen this happen in deals that we've done where right in the middle of negotiating the deal, unfortunately, the influencer engaged in some conduct that became viral, and the brand, luckily dodged a bullet, and, they were in the middle of negotiation, so they abandoned that influencer. But let's say you're a brand and you did sign the deal. So what are you going to do to make sure that that influencer does not tarnish your reputation? So that's where the morality clause comes in. The morality clause basically allows the brand to terminate the contract if the influencer's behavior harms the reputation of the brand. So what are some examples? So there's something that we like to call the bad behavior clause. So if the influencer engages in illegal conduct or even unethical conduct, like for example, fraud, that's going to be something that allows the brand to terminate the agreement. Another interesting clause is a reputational impact clause. So this is where the influencer said something or did something, let's kind of harken back to a couple years ago where folks were getting canceled. um, that really emerged because there was such a public outcry when certain behaviors became public knowledge. And because of that, now brands are protecting themselves by putting in this reputational impact clause. So here's the kind of tricky part. Some courts, are going to enforce these morality clauses, and some are not. But the bottom line is there needs to be hard evidence that whatever the influencer did actually harmed the brand. So there's a legal theory that causation, you really have to be able to tie that behavior to the harm to the brand. Okay, SAG-AFTRA. I think a lot of us who are already in the entertainment space have heard of SAG-AFTRA. It is the labor union that represents um, folks that are on the screen, whether it's film, TV, radio. It's an acronym for the Screen Actors Guild. And then a couple years ago, they merged with the American Federation of Television and Radio Artists. So now it's SAG-AFTRA. So there is a contract that SAG has for influencer produced content. Um, for commercial purposes, those agreements are going to be covered by SAG. So the criteria for applicability is the content has to be in connection with digital distribution, and then the content itself has to qualify as an actual commercial according to what SAG-AFTRA standards are. So a lot of folks may not know what exactly is a SAG-AFTRA agreement. Well, it's essentially a collective bargaining agreement. It's a contract that the guild has negotiated on behalf of its members. With respect to influencers, it outlines the terms and conditions of influencers, ensuring that they're paid fair, they have, reasonable working hours and other benefits. Um, there's two agreements for influencers. There's the actual influencer agreement that SAG has, and it basically gives the influencer an opportunity to become a SAG member. Um, they have to sign a contract that outlines their rights and responsibilities when they are creating sponsored content. And then the other agreement is an influencer waiver. And so this one allows brands to use influencers without fully adhering to the full commercial contract. And this is usually going to be applicable to situations where the influencer produces their own content and the brand isn't really involved in it that much. So think of like more organic videos that really give the influencer a lot of creative freedom. Um, we have another pop quiz here. A brand is looking to collaborate with an influencer who will produce their own content with minimal guidance from the brand. The content will be shared on the influencer's social media platform and is not intended for high budget commercial production. Which legal option would likely be the most appropriate for this scenario? I think it's kind of obvious. Um, I think this is going to be under the influencer waiver, and the key here is um, the minimal guidance.
Okay, more fun stuff. We're going to jump into some government regulation. So, you may or may not know that the FTC has actually very strict guidelines for influencer advertising, and influencers and brands both have to follow these specific guidelines. Otherwise, they can face quite a few different penalties. So, the FTC stands for Federal Trade Commission, they do regulate the influencer advertising industry. And the reason that this falls under the Federal Trade Commission and, obviously their interest in regulating this industry is to prevent misleading marketing. So, in order to prevent this, misleading marketing, the endorsement has to obviously not be misleading. It cannot be false or deceptive. So, an influencer can't come in and say, like, oh, this is the best protein powder I've ever had in my entire life, if it really isn't. So, on that note, they also have to be the honest opinion and experience of the endorser. This one's a little bit harder to obviously police because whether something is your honest opinion or not is subjective. So this one's a little bit more difficult, but um, some influencers have run into issues with this where they do say, oh, this is by far the best protein powder I've ever had. And then they get caught at the gym repeatedly drinking a different protein powder or something like that. So that would probably be considered a bit deceptive or not be an honest opinion. So influencers have to be very careful since they are pretty much consistently in the public eye of what they're doing, what they're using, what they're saying, because even if it's not something that they post, but it's on someone else's post or their girlfriend's social media live post or something, they can still be on the hook for something like that if they get caught misleading the public. So they have to be very careful with what they do. One of the most important things, which a lot of influencers have been busted for giving rise to this guideline, is that there has to be a sponsorship disclosure and it has to be in clear and conspicuous language. So somewhere in the post, whether that be like on the actual post itself, conspicuously right across the center or right across the top, or even in like the caption of the post, there has to be some kind of sponsorship disclosure. And generally speaking, a hashtag ad will meet this guideline. So you don't have to blast, you don't have to do like a 2-minute introduction to your live post saying, this is brought to you by X, Y, and Z brand. You don't have to make it, super painfully obvious, but it does have to be clear and conspicuous so that anyone scrolling through your posts can see it. We do have another pop quiz. This one's only, multiple choice, so this one should be easy. The question is, which of the following is considered a clear and conspicuous sponsorship disclosure for influencers under these guidelines? A, hashtag ad or hashtag sponsored, placed in a small font at the bottom of the post. B, this post is sponsored by brand name, clearly placed at the beginning of the caption or the video with no ambiguity. C, a vague mention of the brand in the middle of a post with no specific hashtags or clear indication of a sponsorship. Or D, a general statement saying, this post is about something I love without specifying any brand or compensation. I'll give you guys a second to think about it. Okay, so the answer for this one is B. This one may have been slightly tricky because we did mention being able to do the hashtag ad, but that has to be in a very clear and conspicuous place. So Um, A is not the answer because this is indicating that it's small font at the very bottom of the post or too far down into, a caption or something like that. So the answer for this one's going to be B. It has to be sponsored by this brand, and it's clearly placed either at the very beginning of the caption, not buried down below, or placed on the video so that it's very clear, right? So why FTC compliance matters. Obviously, it's a government entity, so it's important to follow their guidelines. But specific to you, you may be asking, why will it matter to me? Will they catch me? Am I going to be on the hook for anything? So, some of the penalties and investigations for deceptive advertising have led to court cases where brands have been sued by the FTC. For example, the Teamy case was just from last year. Basically, the allegations were that this company the owners of the company and certain famous influencers made weight loss, cancer prevention, migraine relief, unclogging arteries, immunity boost claims, basically all of the wellness under the sun. Apparently, this product could do it, right? Um, the company, the owners, and the influencers all earned over $15 million associated with these claims because consumers believed it and bought the product. Some of the influencers involved are names I'm sure you guys recognize: Cardi B, Jordan Sparks, Adrian Bylone, Brittany Renner. A ton of influencers were involved in this case. The legal violations that were brought against this company was obviously misleading advertising. A lot of these paid endorsements weren't disclosed as endorsements by the influencers. So they didn't use that hashtag ad. They didn't say in the video, this is sponsored by, this company. So they didn't adhere to those FTC guidelines. They also didn't clearly state that they were connected to this company at all. And the ones that did, they hid it so far down in the caption that someone had to click on that more button on Instagram to see it. And the FTC said, you can't do that. It has to be clear and conspicuous. So a regular consumer shouldn't have to, click some buttons or scroll super far down to figure this out. So it does have to be very obvious and on the first page when you're scrolling through your feed. They also apparently violated their own policy. So this is a classic case of a company saying, "But look, we have this policy," and the FTC said, "Yeah, but you didn't even follow it yourself." So the company had implemented a disclosure policy, but the influencers failed to follow it. This led to not only the violations against the influencers, but the brand was also on the hook for it because they didn't police their influencers and they didn't tell them to adhere to this disclosure policy. So because they weren't enforcing it, they were also held responsible. So that's something really important for brands to know. You are responsible for your influencers' actions. So you need to make sure that you're checking their posts, making sure they follow all the guidelines, etc. Just having the requirement in a contract isn't really enough for the FTC. This company ended up selling or settling, and the settlement terms were that the company could no longer make false health claims for obvious reasons. They had to provide clear and conspicuous sponsorship disclosures, and there was a $15.2 million judgment in favor of consumers in the FTC. This was partially suspended after a $1 million payment, but they still may be on the hook. Another example of a case is the Genshin Impact case from this year. This is a really recent case. Cognosphere agreed to pay $20 million in this settlement and block kids under 16 from in-game purchases without parental consent. So this is really limiting and a really big settlement that they agreed to pay. The allegations against them were deceptive practices that misled minors and players about the real cost and odds of what they would get if they made an in-game purchase for a loot box. So there was a complicated currency system involved. People and players were kind of misled about the real money and what their odds actually were of winning a rare prize in one of these loot boxes. Prominent influencers like Fixeye, Vicky Show glamorized the loot boxes to kids, and kids were going in and buying these things because they didn't understand like the real money cost. They thought, oh, my favorite influencer told me that I was going to get this rare prize, so obviously if I buy one loot box, I'll get the rare prize. Um, so the influencer campaigns really gave players the incorrect impression that they would have much better odds than they actually did in reality. So the key impact of this case is the FTC emphasizes holding companies accountable for using, quote, dark pattern tactics, especially targeting vulnerable players like kids.
All right, I think this is the last case we'll be discussing because I know discussing court cases are like really, really interesting for everyone. Uh, this is the Car Shield litigation from 2024, and this also resulted in a settlement where Car Shield had to pay 10 million. The charges were for deceptive marketing and misleading celebrity endorsements. Basically, CarShield was issuing ads that promoted peace of mind and protection should consumers use CarShield to get their repairs covered in case anything happened with their vehicles. I think what happened was that consumers who had CarShield went to car repair shops, and the car repair shops basically kind of laughed in their face, saying, "No, we don't take CarShield." When it was CarShield themselves that was like, "Hey, use us. Everywhere will take us. Like, don't worry, we got you guys." They even used celebrity endorsements from Ice-T, Walker Bueller, Chris Berman, but it turns out they weren't actually real customers. So the FTC found that there were misleading claims that all repairs and systems would be covered. There was false assurance of rental car availability during repairs, celebrity endorsements, and consumer testimonies were deceptive. They prohibited future misrepresentations in advertising, required truthful endorsement disclosures, and a full 10 million judgment used for consumer refunds. All of that to say, you should comply with the FTC because this is the last thing you want to end yourself in or do. Okay. I think we're moving on to our FAQ session. So what happens if an influencer breaches their contract? If an influencer breaches their contract, they may face legal consequences like having to pay damages or losing out on their compensation. But I think one thing to note is like also if an influencer breaches their contract, they're left vulnerable to a dispute resolution process, whether that be going to court, arbitration, mediation, and those things take time and energy. And that's the last thing a busy influencer wants to be involved in. So yes, you might have to face legal consequences like pay damages, but you will also be embroiled in a dispute, which is difficult to juggle on top of what I'm sure is a very, very busy life. Are influencers liable if they promote a product that turns out to be harmful or defective? The answer is it depends, which I know is not a great answer to hear, but truly it depends. Influencers have a responsibility to ensure the products that they endorse are safe, are good, are reliable. If a product causes harm, they could face legal consequences, including lawsuits or penalties, especially if they misrepresent the product or fail to disclose important safety information. But this question is a little difficult to answer because it also goes into, well, what was the brand itself saying? What were their practices? How did they make the product? What led it to be harmful or defective? So truly, it kind of depends. How can influencers ensure that they are properly disclosing sponsorships in live streamed content? I know in recent times, especially since COVID, live streaming has been a huge thing, whether it's been on Twitch or YouTube, I think now offers live streaming. If you are an influencer and you are making live stream content, you should clearly state that the content is being sponsored by mentioning it both at the beginning of the stream and throughout, because people might jump in, midstream. And you also want to make sure you're using hashtags clearly and conspicuously, like ad or sponsor, to stay transparent. I think depending on the platform, there should also be like a little description of the stream. You should also include it in the description as well. I would say err towards being more transparent rather than less transparent. If you can create a little blurb that like runs across the screen periodically, or even just like leave it on the screen, maybe try doing that just to make sure that you are in compliance and not in danger of being non-compliant. And then how can influencers and brands handle disputes over content ownership or usage rights? Luckily, we kind of went over this. You should clearly outline content ownership and usage rights in the agreement. If a dispute arises, they can negotiate a resolution or seek legal mediation, but you should have clear usage rights outlined in the agreement at the very beginning. All right, Q&A time. I know we've been answering some questions throughout already, and I think we have about 12 minutes left, but let's see if there's any, if you have any questions, now's the time to drop them into the chat. And yeah, let's see. I'll give you some time. Or maybe this PowerPoint was so thorough, no one has questions and they have all the information they need.
Why don't we read Megan's question, because I think it's a good one.
Okay, yeah. So this was a question that we got from Megan. Hi, Megan. And it was, I think it was in reference to the morality clause or the morals clause that you had talked about earlier. And it was who determines what's classified as an unethical action? And I would take it even further to say, like, who determines what is what brings the company into public disrepute or harms the reputation. And it depends on how the clause is drafted, but usually you want the clause to state, like, this is to be determined based upon the objective, reasonable person. In other words, what would the public or just the normal average Joe reasonable person consider to be an unethical action or to bring someone into public disrepute. If you are an influencer, the last thing you want to do is leave that up to the brand's discretion, because you don't want them to decide, okay, you know what, this harmed our reputation, so we're gonna terminate the agreement. Or like, we think this is unethical, so we're gonna terminate the agreement. The last thing you want to do is to give a brand that right. But even if you do, you want to make sure that it's reasonable, their discretion. So yeah, it depends. Make sure the clause is drafted clearly. Thank you, Amira. Let's see. Let's see. Are foreign nationals who are influencers allowed to produce content in the US on a tourist visa?
I think that's a question for an immigration attorney.
It's like, actually,
Yeah.
don't.
We are not immigration attorneys, so I don't think we are capable of answering that. However, we work very closely with an immigration firm that represents entertainers, and if this is something that you need counsel for, we're happy to make an introduction.
Mm-hmm. Any other questions? Oh, we got one from, yeah. For brands targeted at a children's audience, how complicated does the agreement get, particularly around morality clauses?
I would say that it's going to be more stringent with children. If you're specifically, targeting minors, everything is usually more stringent.
Mm-hmm.
So the answer is, it's not complicated. It's just going to be more thorough.
Cool. All right, last call for questions, and I think we'll call it. Okay, yeah. All right. I think no more questions. All right.
Thank you guys for coming. We love doing these webinars. We feel like it's giving back to our clients and the community. If you guys have a topic that you're interested in, please reach out to us. We're always looking for ideas. And who better to hear from than our clients in the community. Thank you, and we will see you at our next one.
Bye, everyone.
Thanks, guys.
Thank you.